Hi, good evening, and welcome to Life in Focus. My name is Stephen Akinsanya, and I'm a barrister practicing at Great James Street Chambers in London. On tonight's show, I want to discuss with my guests a very important piece of legislation. It's a piece of legislation that has caused me a lot of concern in the years that I've been practicing criminal law, particularly with murder cases. And I asked the question this evening: joint enterprise, are you guilty by association? Now, as a practitioner in criminal law, and with the many murder cases that I have been involved in, almost all of them have involved the law of joint enterprise. And my most recent case caused me to pause and think about this law and the effect that it's having on communities, and disproportionately Black and ethnic minority young men. Often, when you're downstairs in the cells at the Old Bailey, it dawned on me, looking at groups of young men being led to different courtrooms, 7 in one group, 5 in another, 4 in another group, all young men, arguably between the ages of 14 to 25, charged with murder offenses. And I asked myself, why is this? Can they all be principals as we know them to be in law? What's their involvement? Why are so many young men all being charged with the murder of usually one individual? What's behind it? And I was concerned enough to speak about it to communities, concerned about it to write in professional journals. The law of joint enterprise, what does it mean? What do our communities understand it to mean? How is it impacting our young people? And what should they know? Joining me on tonight's show are 2 experienced guests who are going to help me go through joint enterprise and discuss some of the salient issues which members of our community need to be aware of, and things that we need to do in order to continue to challenge this law and to understand it, so that we can educate our young people about how easy it is to find yourself involved in a serious criminal offense, not as the principal, but as a secondary party because of association, and how the courts and certainly the prosecution go about bringing these cases to court and then before a jury. My first guest is a barrister at my chambers. Kevin Metzger is a senior criminal barrister with over 30 years experience. He has an ardent interest in international human rights law and civil liberties. His practice comprises serious crime, private international law, human rights law, matrimonial and general common law. He's appeared as lead counsel in numerous serious criminal cases, trials involving juveniles and adult defendants, and complex civil matters, immigration, human rights violations, matrimonial and child custody. He's registered as an expert on human rights for the United Nations, and Kevin has contributed to seminars and conferences on youth crime and the effect of the Convention on Human Rights on the criminal justice system. He's particularly interested in the treatment of offenders and the effect of Article 6, the right to a fair trial, on defendants in criminal proceedings. He was also called to the bar in Sierra Leone in 1986. I'd like to welcome Kevin to the show this evening.
Thank you very much, Stephen.
My second guest is Gloria Morrison. Gloria is the campaign coordinator for JENGbA. JENGbA is the campaign group called Joint Enterprise Not Guilty by Association. They're a grassroots campaign group made up of families of prisoners convicted using the archaic doctrine of joint enterprise. Gloria is one of the co-founders of the campaign after her son's best friend, aged 19, was convicted of murder using joint enterprise, even though the evidence clearly showed he was not the principal, did not possess a weapon, nor share the intention of his friend who did. JENGbA was formed in 2010, and they've been campaigning against what they describe as the flawed, racist, and discriminatory use of joint enterprise to incriminate mostly young boys from BAME and working class communities. The youngest person serving a life sentence is just 13 years old. Gloria, I'd like to welcome you. Good evening to both of you.
Good evening. Good evening.
Before we start, can I just share with our viewers just some figures that I have relied on in the past, and they may not be up to date in terms of their accuracy, but certainly reflect the position that there are some 4,500 young men in prison through the joint enterprise law, about 37% serving long sentences for joint enterprise are Black. That's 11 times the proportion of Black people in the population. Now, those figures, to my mind, demonstrate an issue with the use of joint enterprise. And so my first question to both of you, and I'll come to you perhaps, Gloria, first, because of the role of JENGbA, is this: that joint enterprise may have its origins in the noble dispute resolution of dueling, but today it's a racially biased piece of legislation used to round up groups of young BAME men for murder, often being convicted. Is that accurate or an over-exaggeration?
Highly accurate. I actually don't think that figure's correct. We've been trying to get figures from the MOJ about numbers of joint enterprise convictions, and they have refused countless FOIs to try to find out exactly what number we are looking at. JENGbA supporting over 1,140 prisoners currently. Some have been released, some have been deported, some have sadly died, but our numbers are well over, into the thousands. So I still think that's conservative. I'm pretty sure it is, because we don't have the right demographic of young offenders. And that's to do with young people going to prison from different kinds of backgrounds, but mainly BAME and working class, who just don't understand the law and don't understand how they were convicted of a crime as serious as murder. And when they haven't actually committed that murder, they might have been involved in some way. They might have been involved in, the gang association is nearly always used because it's an easy trope to set out. But I think the numbers are going to be much, much higher than that. I think that because our prison population has doubled, we're up to 90,000 in the space of 15 years, we have to look at something like joint enterprise and IPPs as a result of that overcriminalisation, and to give the prosecution and the police a sledgehammer that is joint enterprise. That doesn't means you don't have to actually produce evidence on individuals. You just need to put them together and say they're all in it together. They know, what your friend was going to do. Friends tillage everything. The same old kind of rhetoric is dealt out in the courts because it's a very, very easy way of getting a conviction. And what people aren't realizing is these are mandatory life sentences. So you might have a boy that's really on the periphery, that's very young, that might be vulnerable, might have learning difficulties, but that doesn't matter. If they get convicted of murder along with the principal because they knew the principal, they shared a phone call with the principal, they will get a mandatory life sentence along with that principal. So if the principal gets, say, we're seeing on average now 20 years, they will serve 20 years, even though they haven't committed the crime.
Yeah, thank you, Gloria. And Kevin, obviously from where we are as defense advocates, we're in the courtroom defending these young men on joint enterprise cases. And obviously in your many years of experience, as a lawyer, what are your thoughts on the way in which joint enterprise is used by the prosecution in cases of murder, disproportionately affecting young Black males? And I have to say that almost every single murder case I've done in the last 27 years has involved young people from the BAME community or working class community. What do you say, Kevin?
Well, as you say, Stephen, in our profession, we come across a lot of young Black people who are accused of the most serious of crimes. And I think just going back to the way you, as it were, started this, talking about, going back to the noble art, some would say, some might snicker nose at it, dueling. We have a situation where I think for a long time now, there's been a perception amongst BAME communities that this doctrine is being used against young black men. And a way of looking at this is looking at the type of evidence, and we may well touch upon this later on, looking at the type of evidence that the prosecution will traditionally or habitually use in these cases. So we're looking at social media, we're looking at WhatsApp messages, and we're looking at YouTube videos.
Yeah.
These are all things that these communities, our communities, the young people are very much involved in. And in previous times, I suppose, people were not that exposed because we didn't have that sort of outreach, because we didn't have the internet. But now it's all out there, it's all public for people to see. And the prosecution can use any opinions expressed in any of this media as supportive of an intention to be involved in serious crime, not least of all murder. And I think that is part of where the problem is, that society, or the criminal justice society, has allowed this to happen unabated.
Yeah. And in fact, you're right, Kevin. We will be returning to that aspect of the discussion shortly. But one thing that it seems to dawn on me is that demographics seems to play a part in all of this, where young people live. So many of the cases that I've been involved in, you've got a kid who lives on a council estate or in a block of flats somewhere. It's normal for a lot of the young people to socialize together after school or college or wherever they are. That's their network. Those are their friends, and often the fabric of an incident happening is woven into that to establish more to a relationship and a friendship than actually exists, in terms of people saying, well, you're gang members because you hang around together. And I just wanted to touch on that, Gloria and Kevin, but Gloria first. How much does the demographic of where these youngsters live play into the joint enterprise mode of prosecuting young people, the fabric of it? What do you say about that?
Well, I think it's a combination of it's a combination of what the police, and I don't want to be seen as police bashing, because that's not what JENGbA are about, but the police set a narrative in their heads and they will pursue that narrative. So if we're in Bradford, it's the Asian community. If we're in London, it's the black community. It's very easy to target groups of people. I was in court at Snaresbrook, where the judge's comments were, all these people, these boys, and they were ranging between 15 and 19, these young people, they phone each other more than they phone their fathers. Well, how out of touch a comment is that from a judge, that young people contact each other via social media than they would their fathers? It's just a nonsense. And I forgot, actually, because you brought up the idea that about the dueling. You know, what people don't realise that is our law, homicide law, has never been put in statute. That's another big discussion, but we won't go there. But you know, it's common law, and people don't understand that means that it comes down through the judges. It's not something government have looked at and thought, well, we need to actually establish what exactly is going on here, you know, in terms of joint enterprise. And so if you're using laws that are that archaic, like Kevin just said, you know, if you're looking at things that are about a race in 1848 where two men are racing each other and a bystander's killed, that was brought up in the Supreme Court, that case. Now, how is that relevant to a young group of people who are living on estates, who might be selling weed, might not, might just be friends? How is that relevant to their lives? And they will still refer back to these kind of laws. So it's such a messy doctrine, and it's so easy to target young people that probably might be getting into some kind of criminality because there's nothing for them. We've had austerity for years and years. I'm not excusing the behaviour and the fact that we have victims of crime here. Absolutely not. But most of our families, in fact, every single one of our families that are all up and down the country, would say if they've done the crime, would support them, but don't put them in prison for a murder they haven't committed. And that's a lot of families.
Yes, indeed. And Kevin, I mean, as I say, it's just something that I've been conscious of with the cases that I've been involved in, the demographic of where a lot of young people live, and it feeds into the narrative of gang activity when it's not always borne out by the evidence. It's an easy assertion to make. It's all too often made as part of the case. And so the fabric and the demographic of where young people live, certainly to my mind, plays a part. I mean, I don't know if you have a contrary view or you accept that.
Well, I do accept that, but I'd just like to sort of throw this into the melting pot. Is this a chicken and an egg situation? Because what we have here, societal pressures or perceptions or realities affecting the lives of people wherever they live. And we know from the job that we do that, you know, all this started with the police collecting intelligence. It's a very important part of the work that the police does. But what is that intelligence really? It may be a community support officer or some officer who is tasked with going around and seeing who hangs around with who. Because a group of young people may be sitting on a wall in a neighborhood. They may be smoking, as you know, we've discussed here. They may be smoking weed, or they may just be talking. They may be drinking alcohol. They may be doing the sort of things that teenagers kind of do when they don't want their parents to know about. But they are not necessarily involved in criminal activity. Now, a police officer going by looking at them may have decide on stopping and asking them questions, getting their names and addresses, and creating thereby a gang that.
Kevin looks like he's frozen there. Are you?
I'm still.
Are you there, Gloria?
No.
Okay, Kevin, you've come back. That's okay. Do you want to continue? We just had a freeze.
I was just saying that sometimes one has to look at this situation and consider whether or not some of the things that we're looking at, the gangs that we're looking at today, and the way in which they have grown were brought about by the way in which intelligence is gathered, and people are tarred by the same brush.
Right. Now, I'm hoping that a lot of young people are watching this, because often when I speak to groups of people, it's always the parents or older members of the community, when really the people I really want to hear this message about joint enterprise are the youngsters. Now, I'm hoping that they are watching. And Kevin, I would really appreciate if you could, without being over legalistic as best as you can, just to explain to our audience about joint enterprise in the sense of the principal and secondary parties, what is meant by this term parasitic accessory liability? Is it redundant? And then obviously with the current law, an accessory through assistance and or encouragement. If you could just summarize that for our viewers, I'd be grateful.
All right, thank you, Stephen. Well, putting it simply, the principal party is the person who did the deed. So we're talking about murder, the person who actually struck the blow. The secondary party is a person or persons who are associated with that person. Generally, they tend to be present at the scene. What the law says is that they are people who are said to have assisted or encouraged the principal, the person who did the act, in doing what he did. Now, it becomes a bit complicated when we're looking at assistance or encouragement, because the law says, and every judge will tell every jury in that specific circumstance, that mere presence at a scene is not enough. But if you are there with the intention of trying to help somebody or being there as a backup.
Indeed, being there as a backup, then you could in fact find yourself guilty as a secondary party. I think that's what Kevin was going to say. Sadly, we're having some sound issues with that. But hopefully we can come back to Kevin. But Gloria, you're there, aren't you?
Yeah. I'd like to give you a case scenario. I've had some wonderful women in the office today that are trying to galvanise a youth arm for us, a JENGbA youth arm, and they were marvellous. So we were going through cases, and I said, oh, and the thing is that these are two, one's doing a PhD at Oxford, one's got her own organisation called Set in Hackney, which is trying to do outreach work with young people. And so they know about joint enterprise, but the level of shock that both of them experienced when I was saying, well, you've got this case, I could do names, but it's fine. You know, this is a boy, a man, 19 years old, he's dealing drugs. He's gone into a flat. He sees two men having a fight. He says, stop it. What are you doing? Stop it. And he leaves with the person that was involved in the fight. Now, he's left. Unbeknownst to him, this person has already stabbed that person. He didn't know that. And actually, he stopped a fight. The prosecuting witness agreed. He had stopped it and left. He gets found guilty of murder because the victim sadly dies. It goes back to the Court of Appeal on the fact that, you know, he's the person who stops the fight. So how can he be guilty of intention? Because that's the things we need, which Kevin was describing in joint enterprise. You need to be able to show that you had the intention and the foresight that someone was going to kill someone. So he gets acquitted. Great result. We don't often get many of them. CPS always get another bite of the cherry. They take it back to court and he gets convicted again. He's still serving a life sentence. So, you know, case after case, I could tell you where you think how you extricate yourself from a joint enterprise. You know, even if you see a fight and you try to stop it, which we've got lots of cases where people have tried to stop a fight, or they've gone to the police to inform the police, they get drawn into the joint enterprise. So it's such a mess and it's so dangerous, and it really, and also I just would like to point out, if joint enterprise was such an important part of the legal armory of the police, why do young people not know about it? I know, Stephen, you said you talk to your community groups and dads and nobody knows about it. Our biggest battle as a campaign is when you tell people, I call it the jaw drop moment, they go, that's happening in England. You can go to prison for life for something somebody else has done. And people just don't believe it. And that's part of our difficulties as a battle as a campaign, because people just can't believe this is happening today in the UK. Absolutely. And it is. Well,
I can echo that, because I spoke to a group of fathers and men in a church group last week, and they were astounded when I explained joint enterprise and gave them real life examples of cases that had happened. So it is something that I'm very passionate about sharing in the community, people knowing what joint enterprise is. And Kevin, just returning, if we can, after the break in the link there, listening to what Gloria said and talking about accessories and assistance and encouragement, can you give our audience examples of the level of assistance or encouragement that would be sufficient to convict you of murder? Because they may be shocked.
Very simple example. This wasn't a murder case, but I think it's a case that Gloria will be aware of, because I'm sure the mother went to JENGbA. I represented a young man in Manchester several years ago now. He was the driver of a car. He'd come up from Birmingham. Another car was behind, and his passenger, unbeknown to him, took out a gun and shot someone. As it happened, that person didn't die. So he was very fortunate that he wasn't, on trial for murder. It became effectively possession of a firearm with intent to endanger life. Now, that's a fairly serious offense as well. Now, there came a point in time where the jury asked a specific question. The question came back: if we are sure that these people hadn't planned it from Birmingham, but this man was shot without them knowing it, can we convict anybody on the basis that on the spot they helped him? And you know what the answer was? You know what the answer was? It was yes.
We're being hampered by the link. Hopefully Kevin will come back. Whilst we wait for that to happen, Gloria, Kevin, are you back here?
I hope so. I think
right. Yeah, we've got you back.
Let me finish just quickly. So what happens is the judge supports the prosecution's standpoint that the driver of the vehicle, who was my client, could have assisted the shooting of that person not on the first occasion, but on the second occasion, because at one point in time, he appeared to pull over momentarily. My client's case was, I was shocked and I pulled over, and I was nervous. I was I was anxious. And he was convicted effectively on that basis. It went nowhere in the Court of Appeal, although they could see the point that I did not have an opportunity, the jury having gone out, to go back to the case and deal with that specific point. And the judge had to say to the jury, this is how you should look at it. Now, post Jogee, one would have thought that is a case that
I think Kevin was going to say that was a case that would be subject to a successful appeal. Are you back there, Kevin?
Yes, it should be. If you can hear me now, it should be subject to a successful appeal on Jogee. But I don't think Jogee goes far enough to allow that.
Yeah. Well, that brings me actually to my next point. We're all familiar, all three of us, with the case of Jogee, which was the case that everyone thought was going to have a major overhaul of the law of joint enterprise, where the Supreme Court recognized that they had taken a wrong turn, or certainly the law had taken a wrong turn when it came to joint enterprise. But I asked this question: was the wrong turn that was accepted in Jogee replaced with minor refinement, producing the same results, Gloria?
Yeah, I think this is very difficult, because I think Felicity Jory is a fantastic QC, and I think the work she did was groundbreaking. And apparently we changed the law, apparently. But I actually think that Jogee was cruel. That's my feeling, because it set the expectation for so many innocent convicted people that they were going to finally get justice, and that we were going to be able to get some kind of retrospective look at their cases. And and these, like I said, the youngest we're supporting is 13 years old. It's like, you're sending a child to prison for life when they haven't actually committed the crime they've been sent to. So Jogee kind of gave us all this renewed hope that, years of campaigning, we intervened at the Supreme Court with Jogee. I saw footage of the Supreme Court recently, and I didn't realise that Lord Thomas, who's the Lord Chief Justice at the time, sat in on that judgment. So what my feeling now about Jogee is that what was happening is that joint enterprise was sort of ratcheted up by the Labour government. Actually, it was in Blair's time, when we were talking about black on black crime. So they started bringing it back in more or less in 2006. We've got cases much earlier than that, but really the bulk of them, and when my son's best friend went away, was 2006, 2007. You're really starting to see a rise in joint enterprise. So by the time you get to Jogee, 2009, no, what date was that? I'm terrible with dates, but anyway, they were looking to a way of putting a stop on people going back to the Court of Appeal. Because if you've been convicted of a murder and you haven't convicted a murder, and we're not just talking about men, we're talking about women as well. We're supporting over 90 women who've been convicted of murders that they haven't committed. You will go think, right, I've got to rectify this. I'll go back to the Court of Appeal. So the Lord Chief Justice was just seeing too many cases coming back, because he actually said at one point, who is going to pay for it? So case after case was going back to the Court of Appeal, trying to rectify the fact that they've been wrongfully convicted. They were getting knocked back. So what he needed to do, and this might sound very cynical and very conspiracy theory, but it's not. What they needed to do was stop that. So they picked a case, which is R versus Jogee. I know Felicity fought for it, and she kept her teeth into it, and got back to the Court of Appeal. And they said, oh, well, actually, the law's taken a wrong turn in 1984, interest in use of a year. But they didn't say it taken a wrong turn over here. Where did it take a wrong turn? It took a wrong turn in Hong Kong in Chan Win Soo, and it took a wrong turn in Jamaica with Ruddock. So what you've got, the Privy Council and the Court of Appeal, Supreme Court, you've still got this idea of colonialism, looking at these two cases around the world that actually we're not getting anything wrong in the UK, because our justice system's perfect. We don't do that kind of thing. So the law took a wrong turn in 1984, but only in cases of substantial justice. It doesn't really matter. And that was Thomas. Thomas put that, whatever it's called, codicil, he put that bit in. Only in cases, it doesn't matter that you've been tried under the wrong law, only in cases that can prove substantial injustice can then go back to the Court of Appeal. So basically, They just put a stop on it. They just, and then the cases that went, R versus Johnson, the autistic children, the autistic boy Alex Henry, and Joe McGraw, all these cases that were really, really so screamingly innocent people. Nope, knocked them all back, knocked everybody back since Jogee, and it was to say, go away, stop moaning, we don't get it wrong. And it's colonialism, and it's, you know, it's out of touch judges who have no idea what it's like to grow up in a West London housing estate, and it's disgusting.
I think I'm right in saying, Kevin, before I get your thoughts on Jogee, that since that decision, I've only been able to identify one case where the appeal was successful post Jogee, the case of Crilly. That's right. And ironically, through further research, I found out that John Crilly was the man who was on London Bridge who apprehended the terrorist at the foot of London Bridge. He happened to be at that meeting for ex-offenders, and it is he who was successful at the Court of Appeal, overturning his original conviction for murder. Now, before I get your thoughts on Jogee, I want to be clear to our audience, and Kevin, as a defense counsel like me, I want you to just tell our viewers, if you were convicted as a young man of murder, joint enterprise, with a knife, can you give a category range of the type of sentence that a young man is looking at? Firstly, for use of a knife, and also where a gun has been involved, just so people know, because I hammer this point home when I talk to groups of young people. I think his screen's frozen.
Having difficulties here. Do you mean convicted of murder with a knife and then convicted of murder with a gun?
Yes, but also on the basis of not being the principal, but being a secondary party through joint enterprise.
You get a life sentence just like the principal.
Absolutely.
And all that happens is your tariff slightly changes. And if it's a knife, you may end up with something like 25 years or 25 years. If it's a gun, you know, you might end up with a tariff of close on 30 or more.
Absolutely.
It's getting worse in terms of tariffs these days. And there are no gradations of murder. I mean, there's nothing, for example, that would say, for example, like in the United States, you've got first degree, second degree, third degree murder. Here, murder is murder. Whether you're a principal or secondary party, you get the same sentence.
Now, we're all aware of that shocking case involving the police officer who was killed when he was dragged to his death with a car pulling away. And that's prompted his fiancée, perhaps quite rightly, looking at a change in the law for whole life terms where police officers are killed or those in service. What would be the position under the joint enterprise law if the law was changed for a whole life term for murder? Am I right in thinking that a secondary party who's convicted of murder on that basis and the law had changed would be subject to a whole life term as well?
Oh, absolutely. Absolutely. It would just have to be. It's as simple as that.
Yeah. And so, Kevin, just so we can finish off with Jogee, what were your thoughts when following that decision? I mean, we've heard about the wrong turn in the law, and Gloria's referred to the basis upon which they reached that decision, referring to cases which were non-UK cases, and then the little fly in the ointment, as it were, of the substantial injustice test. What's your thoughts about that?
Well, I think I've read Jogee now seriously from start to finish about 20 times at the very least. I was very excited when Jogee came out and I saw the summary, and then I read through it. And as Gloria says, a lot of lip service, in my respectful view, is paid to the fact that everybody felt that this whole joint enterprise system was wrong. And what their lordships did in that case was agree with all of us, all the activists who'd been campaigning, but then said, do you know what? Instead of actually looking at some evidence and seeing it as evidence of contemplation or foresight, what we will do is we will say the judge is allowed to say to the jury, these are the circumstances from which you can find it. instead of directing them, that they could find it from that, passing on the buck to the jury. So effectively, a lot has not changed. And over and above that, Jogee was there to make sure that if the barn door was open, the yard door was very firmly shut, so that nobody would go back and say, oh, by the way, there are these thousands of convictions where people have been convicted on similar facts. And it's all a question of what is.
The gremlins are out to get us, but we will press on. Whilst we wait for Kevin to come back in, Gloria, I know you've got some concerns about the role of the CPS in all of this and the charging decisions and access to charging decisions. Can you just share with us some of your thoughts regarding that? Kevin, I'll come back to you.
Okay, sorry, the internet
That's
is
okay.
not very good here.
That's okay.
Well, sadly, JENGbA tend to get families coming to us after the door's been bolted, after post-conviction. We occasionally do get families coming to us pre-conviction or pre-trial. So when that does happen, I say, please, can you get the charging decisions? Because these aren't in the ether. There must be something the police believe. I think it's 51% chance of a conviction. That is why they can take it to court. It's all about money, so they can't take things that are flimsy to court. So charging decisions for us would be really interesting, because let's take the Moss side case where you had 11 young people charged with a murder. That we got the MP involved in that one actually before pre-trial.
Is that the Haffider case?
That's the one we talked about in the dangerous associations. I don't know the victim's name. Patrick.
Yeah.
So Lucy Powell went to the police and said, well, can I see the evidence? And she was shown CCTV, and she said, well, I can see, sadly, one boy has stabbed another boy. Why have you charged 11? And the police told her that it's just a tactic. Now, it's a tactic that worked because they got all 11, either for murder or manslaughter. So what I would like to see in cases is show me the charging decisions on, say, one of those boys in the Moss side case. Let me see. What was the evidence you had on him that could convict him of a murder? Because you didn't put all 11 black boys, defendants, in the dock. If you didn't put all 11 in the dock and you tried them individually, you wouldn't have got 11 convictions. The fact that you're putting 11 in the dock and you're using a gang narrative means you will get a conviction, because our courts are endemically racist. And we've proved this time and time again, and people aren't angry enough about it. And we have laws that are racist, and joint enterprise buys totally into that. It is a racist doctrine used to over-criminalise BAME communities. The thing is, everybody knows about it now. Well, I went to see Keir Starmer when he was DPP, and he said his hands were tied. So then I went to see him when he was an MP, and I said, well, your hands aren't tied anymore. What, this is over-criminalising far too many people. Yeah. But no one wants to do anything about it because it's too difficult. It's in the too difficult to deal with pile. One would have to admit the endemic racism within our justice system. Two, would have to kind of really look at who's in prison, why they're there, and the sentencing. And we got, sadly, a very punitive society that whenever, like the policeman's wife, just lock them up, throw away the key. Don't think about the fact that, actually what we should be trying to do is work out why young people are getting involved in criminalized activities, why there's no youth clubs anymore. I know that sounds a bit twee, but it's true. That what can we do to actually change a young person's outlook to not believe that, selling weed's the best thing they can do, or getting involved in a gang. And I remember Boris Johnson brought out Operation Shield, and I went to Doughty Street, I think at the time, and said, look, Operation Shield, which was that if you are a member of a gang and you're the minor member of the gang, it doesn't really matter if the head person of the gang kills someone, all of the gang are going to be rounded up and all get sent to prison for the same thing. That's joint enterprise. That's exactly what that is. Yeah. But, I think there was a bit of an outcry at the time, and it didn't actually roll out. But joint enterprise is still being used. I got a call from a grandmother the other day. Her 17-year-old grandson has just been charged with murder in a case in Sheffield, and his dad is in prison serving a life sentence for joint enterprise.
Well, that's terribly sad. I mean, Kevin, being involved in the courtroom, do you have any observations about the role of the CPS? I mean, they're subject to the full test code before they decide to charge. And of course, we as defense advocates will challenge where we can the correctness of an indictment or the evidence upon which they seek to secure a conviction. But beyond that, and the arguments we have in relation to bad character evidence in the gang matrix, which I want to come to, do you have any observations about the CPS and their role?
Well, I think
the gremlins. I should say that I did speak to the CPS. I spoke at a CPS event earlier in the year, and I pleaded with them to take real care with the decisions in respect of their decisions to charge young people with murder. That was one thing I did speak to the National Crown Prosecutors, the Black Crown Prosecutors Association. I addressed them about it. But Kevin, you're back with us. What view do you have about that?
Well, I think the code, if it were to be followed, does give a lot of hope, because there are two tests, as you know, the evidential test and the public interest test.
Yes.
And under the evidential test, there are four things they need to think about. Can the evidence be used in court? Is it reliable? Is it credible? Is there anything affecting the sufficiency of that material? Now, if we look at those four things, that's actually quite a lot of things to look at. But the person who is looking at it, may not be looking at it from a necessarily objective point of view, although he believes or she believes that they're looking at it from that perspective. And there may be a lot.
The gremlins.
I'm finding it frustrating. Even though I know a lot, I'm finding Kevin really interesting. It's frustrating.
Yeah, Kevin, you there?
I am here.
Yeah.
I just wanted to touch very quickly on the 7 things that are a question of public interest. How serious is the offense? So it has to be serious. What is the level of culpability of the suspect? So as Gloria says, if there are 10 bystanders and 1 killer, should you really be charging all of them? What are the circumstances of the offense and the harm that is caused to the victim, which is very important? What is the suspect's age and maturity? So it's in their code. But is sufficient attention paid to it? What is the impact on the community? And you're talking about communities where 11 people are going to serve life sentences from the same community out of a murder committed by 1 person.
Yes.
Is the prosecution a proportionate response to what took place? Same scenario. And finally, do sources of information require protecting? Now, that's the last one there. And you and I know what that relates to, because it's about informants and so on and so forth. But what it does is a let out for people who will cooperate with the police, but not necessarily people who are too afraid to do so.
Absolutely. Now, on the back of that, and if we work on the premise that there's a failure sometimes to follow that full code test, or full test code rather, Gloria, is there, if you can just answer this for me, is there then a perception that the objective is to get as many young men from disadvantaged communities, BAME communities, working class, before the court for murder, rather than have them charged with something else if there is some form of criminality, or not to charge them at all? What do you say about that?
I think absolutely. I mean, we're in a very, our courts are archaic. I mean, you're obviously both black men. Why have you got to wear a white wig in court? I mean, what is that about anyway? But we've got language that young people are not going to be understanding. We've got an ethos of winning, of not getting necessarily the truth. It's like we've had story after story of police cheering or prosecutions cheering when they get a conviction. And I had a conversation to follow on what you were saying, Stephen, about he was doing a talk, the current DPP, Max Hill, and he was supporting a girl called Emma Hall with her CCRC application. Emma, clearly innocent, she's a very vulnerable girl, took the police the next day to where a boy had forced her to drive a man that she didn't know if he was dead or alive, and they then brought her into the joint enterprise and charged her with murder, and she got convicted of murder. Now, Max Hill said to me that he wanted to you know, he did her CCRC application, so he was at this thing. She got knocked back by the CCRC, and I said, Max, what, you know, like, come on, what, Emma's case? And he said, oh yeah, but that one went cutthroat. And I'm looking and thinking, you're the DPP. Stop cutthroat defence. Stop people trying to throw other people under the bus because you're trying to get your client off when you know that it's going to harm that other person. And that's my son's case went cutthroat, you know, and I think that's the point. It's about winning. And I'm sad to say that, because I don't think, you know, everyone's like that, but I do think there's a lot, especially from the CPS point of view. If they finally got something into court, they want to get these convictions. They want to make sure, and they don't care. They don't care about ages, about vulnerability, about whether they've got learning difficulties, whether they're autistic. So we've got all of those kind of narratives in our side, in people who are trying to, you know, overturn convictions that have got no chance of doing it because of the substantial injustice test.
That's right. And, you know, my most recent murder case really brought home to me the fact that, yes, it was a case involving joint enterprise and two young men. But as I sat in that case for around 4 weeks at the Old Bailey, it dawned on me that really, you know, there is no winning and losing. There are no winners in joint enterprise. And that became apparently and abundantly clear for that time spent in that court case when one defendant was convicted, my client was acquitted of murder and manslaughter. You had the family of the deceased broken. I couldn't even look the parents in the eye until one moment when I broke with protocol and hugged the father, because I was so upset to see how hurt he was. But then it just made it clear to me that there are no winners. So it's not a question of winning and losing. But Kevin, a very important feature of joint enterprise is how the prosecution rely on particular evidence in support of a joint enterprise prosecution. And I just wanted you, if you can, we've got about 10 minutes, but I want to share just a few points in relation to some of the things that we see in terms of what the Crown rely on in a joint enterprise murder case.
Okay, so one of the most common things used these days are YouTube videos. YouTube videos of young people from as few as about 10 to 30 odd, doing some form of rap music or grime or what. I'm very old-fashioned. I don't know exactly the type of music that they listen to, but generally speaking, these are the lyrics of this music have sentiments that people would frown at because they don't like the police, they don't like society. It's a young society screaming out about what is affecting them. But by virtue of that particular evidence is used to support their hostility to the police. I mean, I did an appeal in one of the Birmingham riot cases, which effectively, what was left to the jury was the fact that people had participated in such a video, suggested one that they knew each other. It provided evidence of identification where people could not be identified on CCTV footage. It provided at the same time evidence of hostility towards the police and evidence of people's affinity for firearms because they mentioned firearms and that sort of thing. The fact that people sing about it, I mean, you will recall the phrase used by some of our colleagues in cases, you know, when Eric Clapton or Bob Marley sang, "I shot the sheriff, but I didn't shoot the deputy," it didn't give anybody the right to go and put him on a murder charge because he was singing that about shooting someone.
Absolutely.
But, there you go.
Yeah, and in fact, yes, you talk about social media. They also use young people's use of mobile phones. Yes, WhatsApp, Snapchat. So all forms of social media are subject to investigation, if you like, by the police in support of the case. And what I should say is that obviously, as defense advocates, one of the things we do is to challenge the admissibility of this material. But very often, that material is admitted. And of course, it can be highly prejudicial in a case where a jury perhaps are watching what's happening in the media, forming their own opinions on a particular individual, and sometimes taking their eye off the evidence, which is leading to people being convicted as secondary parties.
Yes. And most importantly, can I just add this? The police do what they call open source research. And open source research means they might be looking in an area and picking people's associates and so on from social media streams. And they might create a narrative out of that fits in with the case. I mean, it might fit in with so many other things, but because it fits in with the case, it's presented as evidence. We fight to keep it out. We're often not successful.
But
I think, I don't know whether you've both had experience with this one, which I think is actually quite sinister, that if a young person has run out of credit or their phone dies, or when a serious incident happens, that is perceived as that they've gone radio silent because they know an offence is going to happen. Now, how seriously sinister is that? That you, because your phone is switched off, you know an incident's going to happen. That's evidence that you knew that was going to, you had the foresight that was going to happen. I mean, you're in a no-win situation when you've got these highly intelligent prosecutors. I mean, one of the things we took back to the Court of Appeal was evidence of children not actually being able to understand the question the prosecutions were asking because they had learning ages of 8 and 9. And we took this back to the Court of Appeal, and we had the media in court and said, if you've got a child with learning difficulties, and they're asked a tag question, they will rarely answer in the negative, or they'll always answer in the affirmative because they won't want to say, I don't understand the question. So, you know, how is that a fair trial for a child with learning difficulties? Lord Thomas, obviously, you know, I'm a fan. Lord Thomas said that that didn't matter. He also said that the case of Alex Henry, where we took that back because he's been diagnosed as autistic by the lead expert on autism in the country, Professor Simon Baron-Cohen, he said, yes, he is autistic. And Lord Thomas said that because Alex's mum is she's got a psychology degree. She taught her son how to pretend to be autistic. Now, people might gasp at that and think, no, that's not happening. That happened. That happened in the Court of Appeal. That was his judgment. Oh, his mother taught him how to pretend to be autistic, to pull the wool over the eyes of the lead expert in the country. Now, if that's what you're up against in the Court of Appeal, how are you going to get some black kid who was sitting on a wall when his mate has run down the road and stabbed somebody, and he's phoned him earlier? How are you going to get him out on appeal when you've got the Lord Chief Justice saying, no, he's pretending to be autistic? You know, it's such a mess. Joint enterprise is such a mess. And that's our biggest bugbear. That's our biggest fear. But the mess that's there that we've pointed out, we're being told, go away. Just go away. With Jogee, whatever we do, you know.
Yeah. But, you know, the point that I wanted to look at briefly is we are, unless we do something, and I'm fearful of where we're going in terms of this period of COVID-19, and I'm really fearful of civil unrest happening because people are going to be more inclined to be more stressed as the situation closes in on them economically. They can't leave their properties, or they start to break the rules, and young people are going out and there's propensity for trouble. And of course, with all of that happening, joint enterprise is very much at the heart of something happening on the streets and young people being charged. I just wanted to ask you both, what would you like to see as a sort of true overhaul of the law in relation to where Jogee is and where we're going for the future? Because Jogee has purported to deal with the wrong turn. There's obviously significant questions whether it has in fact done so. What changes would you like to see? We've only got a few minutes, but before I actually do that, would you both agree that with joint enterprise, we are moving, or certainly we're putting ourselves in a situation where people are going to say, we're bleating on about criminals who've committed offenses. would you both accept that there are cases of joint enterprise where some people are not even present at the scene yet are convicted of murder? If you can just give me a yes or no.
Yes.
Yes.
Yeah. So that's my concern, that joint enterprise doesn't just mean people present at the scene. You can be convicted of joint enterprise murder even if you weren't there, because they rely on this association, this encouragement, which can take the form of social media through a phone call.
Yeah.
Is that right?
And that's the danger, Stephen, because that phone call is something that the prosecution could say was part of a plan, or the planning was taking place, even though nobody has got the content of the phone call.
Right, right. Gloria, can I just ask you this? We've got 4 minutes and I want to close off with some remarks. What's the next step for JENGbA?
Well, JENGbA sadly, we were going to present a bill in March, which is the Joint Enterprise Bill, which Alex Henry's sister, actually, Charlotte Henry, has now become a lawyer. And she's, the bill is a draft, but it's to try and get rid of the substantial injustice test, because that sets the bar too high for anyone to get back on an appeal.
Right.
We also have got JEEP4, which is it's an educational program with universities and students to kind of make them realize how easy it has been to get someone convicted for joint enterprise. And we've rolled it out for the last 3 years, and it's been a very interesting tool, because these are not just criminology and law students, but they're potentially going to be practitioners going out there, and to be aware of the dangers of. I mean, I've done some universities where I think they all just want to work for the CPS, but that's another question. JENGbA have got to, one of the things I'm most proud of, it's 10 years, on Sunday it was 10 years we've been campaigning formally, and we haven't stopped, we haven't given up. It's really, really hard. I mean, and especially through COVID, no one has any idea of prison conditions. People have been locked up for 23.5 hours a day. Prisoners are saying if they did this to an animal, the RSPCA would be involved. People in prisons that are Victorian prisons that do not have toilets in cell, so they're having to urinate and poo in bags. And COVID, if it comes back again and the lockdown happens again with prisoners, and that's people who are being allowed out for half an hour. There are prisoners that are being locked in for 3 and 4 days. And if you do that to a young person, a 15, 16-year-old in somewhere like Feltham, the mental health issues are going to be absolutely appalling. But the main thing I think that JENGbA has to just quickly, it's just everyone needs to actually get behind us and fight, because it undermines our justice system so badly that joint enterprise is something, look at the riots. So many young people were convicted of riots. They might have been out just running around the streets, which I know a lot of them were, but so it's about just continuing and not giving up, and staying in solidarity, and trying to get more solicitors to actually speak out against it, like Stephen and Kevin have been doing, and saying, look, this can't be right. It's not healthy for our justice system. Sorry, I took too long.
Thank you. That's right, Gloria. Thank you. Kevin, in a sentence, what would you like to see in respect of joint enterprise? I think we might have lost them.
Oh no.
Well, look, it's been a real pleasure talking to both of you on a very important topic, which is of great concern to me, and there's a lot of work to be done. Gloria, I want to thank you for being a guest, and Kevin also. Sorry about the difficulties with the sound, but I would like to see joint enterprise looked at again, and it remains to be seen whether the Supreme Court will bow yet again to public concern over this law and its application. But in the meantime, we must do all we can to educate young men on the perils of joint enterprise and challenge its application at the charging stage and in the courtroom. No one must forget the loss of life in these cases, the families and friends of the deceased, yet often such grief is also borne by the same group connected to those caught up in this madness. The loss of the best years of a young life is truly shocking. And it's that inspires me to talk out about this. The killing needs to stop. We owe it to the next generation, because the law of joint enterprise has taught me that there truly are no winners. I'd like to thank you for watching the show this evening. I'd like to thank my guests. You've been watching Life in Focus with Stephen Akinsanya from Great James Street, and I'll see you next time. Thank you very much.
Thank you, Stephen.
Standing in the middle of a grass field in the British countryside is the perfect setting to introduce this new and exciting brand launched by the Giving Stream Limited called Your Farmer. Direct from British farms, Your Farmer have a variety of products available. Whether it's a butchery product, diced meats, mince meat, sausages or burgers, or if you're looking for oven-ready products that's been slow cooked by a team of qualified chefs, a variety of potato dishes or vegetable dishes in both a single portion or a family range, Your Farmer has everything you're looking for. British agriculture is so important, and that's why every ingredient Your Farmer use is sourced from British producers grown on farms just like this in the UK. 7 days a week, 365 days a year, our farmers work hard to produce an excellent tasting product using high welfare farming methods. Free range, grass fed beef and lamb, as an example, produces a high quality product. Your Farmer are proud of where they source the ingredients from, so much so that they've bespoke built a footprint system so you, the consumer, can trace every ingredient within the meal right back to the British producer. One simple scan using the Your Farmer app or by simply opening the camera on your phone, scan the packaging, and this allows you to trace every ingredient within the meals or within the butchery products straight back to the British producer so you know where your food has come from. The Your Farmer brand has a conscience. As well as supporting British agriculture, the brand has pledged its support to help support people that are living in food crisis here in the UK. Every time a butchery product is sold, a packet of sausages as an example, or every time a farm finest meal is sold, a free meal is then donated to help feed somebody in food crisis. Now, the brand benchmarks its prices against major retailers, so you, the consumer, are not paying for this. This is all done through the profits of the brand. But without your custom, we are unable to offer this support. So if you're an individual consumer looking to do a family shop, or you're a buyer of a commercial or government department, buy Your Farmer. As well as putting great tasting products on the table, you're supporting British agriculture, which is so important, and you're also helping to feed families in food crisis, which is equally important. So go to the store, check it out, download the app for free. This is a nationwide service and you will not be disappointed. Thank you very much for watching this video.